Wow, those cameras are amazing.
That's your take?
Oh no, he's thinking through who's the next lawyer he's gonna hire.
That's so funny.
Woo! I'm Mark Breyer.
And I'm Alexis Breyer. We're the husband and wife law team.
And we're going to comment on some things some lawyers have done in court that we heard maybe they shouldn't have done.
We're off now to Raleigh, North Carolina, and the Wake County Courthouse. Watch closely as this man picks up his personal belongings from the container. Whoops. It's not until he attempts to pay a court research fee on another floor that he realizes his wallet is missing. Inside is $1,600 in cash. Fortunately for him, someone returns the wallet to another security checkpoint in the building later that day. Unfortunately for him, it's missing the cash. So security does some sleuthing. Moments after he drops his wallet, this gentleman makes his way through security and apparently becomes aware of the situation. He and the wallet head to the elevators, just missing the wallet's owner. It looks like he's checking out the contents. He goes up to the 4th floor. A short time later, he's back in an elevator. He gets off on the 1st floor and turns the wallet into security, minus the cash. He tells them he found the wallet in a bathroom. Security's able to track him down and arrest him in court. What was he doing in court? Defending someone. Because he is a defense attorney. He's convicted of misdemeanor larceny, and as a result, he's disbarred, fired from his job, no longer allowed to practice law in the state of North Carolina. Arrangements are made to pay back the $1,600 to its rightful owner.
Wow, those cameras are amazing.
That's your take?
No, but I was just thinking, like, all of these cameras now are so amazing. But I would like to see, like, some of the proceedings that happened, like what he said. But I feel like as an attorney, we have ethical duties, and they literally search back to, we were talking to someone the other day.
Traffic ticket.
Like a traffic ticket. Like when he was 15 years old, he wanted to become an attorney. So I feel like I'm surprised they suspended him.
No, he wasn't suspended. He was disbarred.
Disbarred, yeah. Well,
he's permanently out of here.
I'm surprised that they disbarred him because it's $1,600. But at the same time, I feel like there probably was other stuff going on, and you don't just steal money like that and not have other things going on. Like, you know how they say, like, you say it's your first DUI, but actually it's just the first time you got caught. I feel like if attorneys steal money, then eventually they're going to be doing that to their clients. The disbarred thing, I think he probably had other stuff going on, because I don't think people get disbarred so easily, but that's my feeling. What do you think?
Steal money from people every day, but they do it by charging in 6-minute increments for massive amounts of work they didn't do.
Got him! I'm just kidding, lawyers of the world. I'm just kidding. Just having fun with the lawyers who bill by the hour. So what do I think? I was shocked that he was disbarred.
Yeah.
People don't know, but you can get private censure. You can get in trouble, but we're not going to tell everyone. You can get publicly reprimanded or censured, like we're going to embarrass you publicly. You can get suspended for a short period of time, like you're not allowed to practice law for a while. You can get suspended for a long time. Disbarment, like you're never, ever, 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 ever again going to be a lawyer in this state for $1,600. I'm not excusing it, but I agree. I was really surprised. For that guy, $1,600 in cash. You hope a lawyer picks it up. You can say whatever you want about lawyers.
Yeah.
The truth is, for all the people coming and going from a public place, you figure a lawyer in a courthouse is the most likely person to go.
He also lied, though. He said that he found it in the bathroom, and he didn't.
He allegedly lied.
He allegedly lied.
They may have lied on the man lying.
So I just think there was probably a lot going on there.
Well, he probably turned it in, not knowing they'd ever catch.
That's the craziest thing. You actually turned it in, like with all the credit cards. And I was thinking maybe they would find out that whoever he gave it to was the one who stole it. But then when he said the thing about the bathroom, I'm like, no, you stole it.
If this was an isolated event, what do you think would be an appropriate punishment besides disbarment.
If this was an isolated event, I think that the attorney should still be punished. I do think disbarment is a little hefty and suspension is a little hefty. You have to take the bar, maybe like a 6-month probation. But on the flip side, why are you stealing money? Like, I do really believe that if you're stealing money, it's just a matter of you just got caught and it leads to a whole host of other things.
My punishment's simple. You are suspended from the practice of law until you've paid that man back every dollar plus every additional fine and everything in his life that you hurt. And when you've paid him back fully, then you can come back, you can go through classes, and we'll keep you on like a 2-year probation to make sure you never do it again.
But what if you let him go back into being a lawyer and he steals even more money from people?
Then it's peace out, dude.
Next, we go to a child custody hearing in Las Vegas, Nevada. The plaintiff is Shelby Bachman, and the defendant, Jonathan King. The couple are arguing over visitation rights for their 2-year-old son, Joseph. The issue is King's unpredictable work schedule. The attorneys are Don Procopius, and for the defense, Machancy Kramer.
Because my client is a UPS driver, his schedule, though, is not a set schedule. It varies. So he has to keep her notified of when his schedule is changing so that she's aware of pickup. She has told him now if he's more than half an hour late, he forfeits his entire weekend and can't see the kid.
Has Joseph gone weekends that he would have expected to see his father without seeing his father?
He has not missed one weekend. Not one.
The threat was made.
I
Not
didn't
one.
ask you if the threat was made. I asked if it happened. You led me to believe that it was happening.
No.
My client has worked with him at times that it was till Saturday morning that he picked up.
There is a problem here.
After hearing from both sides, Judge Sandra Pomerantz points to the lack of cooperation between the parents.
What I see here is parties not being creative. But these two need to be adult enough to say, okay, this happened, where do we go from here?
But Your Honor, and I agree with you. And so what she's done is on these times where she's worked with him, but then I think it was within the last 2 weekends.
I thought you said you agreed with me.
I do agree with you.
Okay, so listen to me. You're going to be done with this case when this case is over and these parties are divorced. They'll never be done with this case. Okay? So rather than complaining to me, it's a discussion with Mr. Procopius being creative.
It appears the judge has struck a nerve with the defense.
My client has come up with all kinds of solutions, Your Honor, and it comes down to what mom wants is what mom is going to demand.
Okay, I don't buy that.
Well, Your Honor, that's how it is.
What I'm telling you is, have you discussed this issue with Mr. Procopius?
Yes, I have in the hallway.
Okay. And has it been a matter of making demands or saying, what are we going to do?
No, it's a matter of calling my client a
Whoa.
Okay, whoa. What? All right, I know you and I have never done a divorce case, ever. Child custody, not our thing. But if that's what was said in the hall, would you tell the judge? Would you literally say, she called my client a fucking bitch?
I think based upon this particular scenario, I probably would tell the judge, but I honestly feel when it comes to family law, the attorneys make it worse. I do agree with the judge. Instead of the attorneys talking back and forth, coming up with creative scenarios on how to work out stuff, they literally, I feel like, make it worse. The barbecue, the attorneys fight over, spend more money on the barbecue that nobody really cares about, and all it does is make the parties pay more money and make the children, in worse positions. So I really think that the attorneys, in a lot of ways, make everything worse for family law.
I'm not here to cast aspersions, but if you get your client really mad in a divorce case, so they fight over the barbecue, who wins?
Right? Nobody. The lawyers.
The lawyers.
And the judge has a few words for Kramer.
I do have experience with you using inappropriate language.
And you know
toward
that I
her.
would admit it if I had done it. And if I was going to do it, I would have done it to her face.
You know what? You want to be a sailor? Fine. Go be a sailor in your private life. But don't be a sailor in my court or in my cases.
I didn't.
Again, I don't judge people with sailor language because I use a little sailor language, but only in my private life, not in my courtroom, not to a litigant, not to an attorney. I don't do that.
I just wanted to stop and say, thank you, Judge. Like, don't be fake about it.
Yeah.
There's times to do it and times not. Lawyers are just people, but when you're a lawyer, you need to rise up and show respect to the process, the parties, and the court. So
I feel like when you're swearing all the time, though, you just swear, even sometimes professionally. And they don't even think about what they're saying until somebody calls them out for it.
then I'm glad she called her out.
I'm glad she called her out, too.
And ma'am, I warn you, one of these days, the State Bar is going to catch up to that. Because if you read the rules, there is an ethical rule about fairness to opposing counsel.
I know that there are also rules about treating people equally without regard to race, ethnicity, or gender. I find it highly objectionable that anyone complains about my language because I know all kinds of male attorneys who have no problem picking up the phone and screaming cuss words at me. So if I am outside there where my First Amendment rights are in full effect, I will say what I choose to say when I choose to say it, and that is my right in this country.
Are you done?
But after a few minutes of civility, the counselor starts up again.
We've spent, 5-10 minutes talking about nothing that is relevant to this case because I, as a female attorney, am being chastised over language that men feel free to use.
I feel this might be less persuasive to a female judge.
I think she's being super defensive.
You think?
Yeah, she's not accepting responsibility or accountability.
Her poor client is sitting there too. He's like awkwardly standing there like, what do I do?
Oh no, he's thinking through who's the next lawyer he's going to hire. First of all, let's say what she's saying is true, because I think it's possible that she gets sworn at all the time by guys, by male attorneys. I don't know if it's true or not, and maybe they get away with it. But there are times in life where you have to rise above it. You're representing a client now. Getting under the judge's skin and defending, all you have to do is say, I'm sorry, I shouldn't have said it. I'll be more careful. It's such an easy out, especially with a judge who was cool enough to go, I use those words too, I just don't use them here. Good point, Judge. I'll do my best. I apologize. And instead, she's got to double down, triple down.
She also is referring to cases and scenarios outside of this, which has nothing to do with what's going on right now.
What she did right now.
Yeah.
This is not persuasive advocacy.
No.
Every single day, and they do.
You are giving me a headache because you're yelling. And I don't like having a
Well, I'm
headache.
being attacked, Your Honor.
No, you're not. Sit down, counsel. I'm done hearing from you.
Unsatisfied with the parties' solutions, the judge orders an evidentiary hearing, which means the parents will submit evidence against each other and the judge will make a ruling. In a child custody case, it can get ugly.
Your lawyers are going to be painting a picture for me in court. And it's not going to be a great picture of either one of you about the other.
Even after the judge makes her decision, the defense tries one last argument.
Your Honor,
I have nothing more to say, and I want to hear from either one of you. I'm going to set the trial.
I understand that.
So sit down.
The couple's evidentiary hearing is postponed multiple times and has yet to be heard.
I think the judge was putting down her foot and saying, this is my courtroom and you're going to listen to me and be quiet. I think she was pretty patient with her.
We only got a slice, but that judge stayed calm, acted like a real person, not holier than thou, and at least in the bits we saw, did her best to try to deal with the fact that these parties wanted to fight about everything. That was the vibe I got, and too many judges think once they put on the black robe, they can now talk down to everybody. But she wasn't like that at all, and still had to deal with some of that nonsense.
What about the client? What does he do in that situation when his attorney is just going off and he's like, I'm not even being represented at this point, it's just her and the judge, and this is relevant to my case?
I'm glad you asked. What I wanted him to do was stand up, walk over to the other table, grab his wife's hand and say, let's get back together and be done with these idiots. But since that was not the perfect ending, he did at least what we saw. Stay calm, stay quiet. And if you think the lawyer you've hired is unprofessional, it's probably even worse than what you're seeing. Go find a new lawyer. People think they're like bound to their lawyer for life. You are not. If you're seeing something that alarms you, go with your gut.
I do think sometimes lawyers are like, I'm aggressive. I have these muscles. Like, I think that sometimes people think, oh, I want this, heavy hitting, aggressive type of person. But actually, that's not the type of lawyer who gets the best results. That's the type of lawyer who, that's what happens. People don't like to give more to people that they don't like.
What do you hear all the time? You don't want a good aggressive lawyer. Good. What do you want? You want a good lawyer or you want an aggressive lawyer? Now, you can be both, but this is not a UFC fight. And who's best at convincing other people is often the person that people like the most, they relate to the most. And the person who goes yelling and screaming and claiming their First Amendment rights are being violated in the hall is probably not the most likely, the most aggressive. But when people are hiring a lawyer, they think through, I need a fighter. You do. You need someone who truly has the willingness to fight, but to do it in a way that will convince people. Because in the end, that's what advocacy is.
Do you think that hurts his case? I wouldn't assume it would, but does that ever happen? Like if their lawyer acts up like that, could they use that, the opposing lawyer?
All the time.
Really?
Judges are people too. Jurors are people too. And while they shouldn't care who the messenger is for the client, you are being judged by your lawyer. It's your lawyer that's doing the talking. The lawyer you hire and how they act and how they relate to the judge or jury has a massive impact on the outcome.
That's why the male attorney isn't going to want to go out of his way for anything for that woman attorney when he's calling, she's calling her client those names. Like, you can tell that relationship between those two attorneys is never going to get those two clients what they need to get.
You want to hear the dumbest part? If just by luck, the woman had hired the woman lawyer and the guy had hired the guy lawyer, the same woman calling her an F&B would be defending everything she did.
Yeah.
Lawyers need to rise above it and help the parties get along. And instead they play this role of, now if you're outside of family law, I don't have to rise above it. I can be there for my clients, be creative, but they don't have to work together. Like the judge said, this case never ends for people going through divorce. When you act all, she's a this, she's that, if she had hired you, you'd love her. So stop pretending like everyone on the other side is evil, but we see that from family law.
Well, I think even outside of family law, the attorneys who have great relationships, you can still be adversarial, but you can still get along with people. You can get the best result in a way that doesn't piss off the other attorney.
The best lawyers I know are feared for their skills.
Right.
But respected for who they are.
Right.
The lawyers who are jerks
right.
end up hurting their clients in the long run, usually.
Yeah.
It's the people who can be both fierce advocates but super respectful.
Yeah.
They win the most.
Most attorneys will tell you it's a pretty smart idea to stay on the judge's good side when arguing a client's case. What's not a good idea is to accuse said judge of serious judicial misconduct.
You know there was jury tampering Wednesday. You saw it yourself.
The man dropping that bombshell is Kentucky Commonwealth Attorney Larry Rogers. And on the receiving end is Judge Vernon Minyard. And he's not receiving it well.
Let me tell you something, Mr. Rogers. I've never tampered with a damn jury in my life. And don't you ever accuse me of that. Do you understand me?
I heard you, Your Honor.
You better understand me.
See the
Hey,
letter?
don't talk. You better understand me.
Your Honor, there is an investigation. I will let you know.
Well, you investigate me all you want.
I didn't-
I'm not scared of anything, because I have never done anything
You
wrong.
said you did.
Rogers is actually referring to another case he and the judge are involved in, which includes allegations of jury tampering and corruption in Russell County.
You just said if you become a witness, you have to recuse yourself in this matter.
I don't know what I'd be a witness for. All I did was, there were some jurors that had to be out.
Yell me all you
I'll
want.
yell all I want. This is my court, and I'll do what I want. Do you understand me?
I said that, but I am going.
Go sit down. I don't want to hear anything else from you.
Turns out the allegations had no merit, and Rogers himself would later be accused of prosecutorial misconduct in several cases, though those claims would also be dismissed.
I think judges are people. However, they do have to make sure that they rise above. I can see people getting their buttons pushed as a judge, but I think you have to always remember you gotta stay calm.
So here's my take. If he had committed jury tampering, he was going to get in trouble for that. Now you're raising that in a different case. As I say to you and the kids all the time, what's one of my favorite things to say to you guys?
What's your goal?
What is your goal?
Yeah, what's your goal?
What is your goal?
Yeah.
You're in another case. You're fighting in another case.
Yeah.
He thinks, stepping in his shoes, he thinks this judge is someone who would tamper with a juror. What is your goal of making that accusation in another case? Is your goal to lose that case? Is your goal to potentially get in trouble with the bar? Like, what is your goal? That investigation is being done outside of this one.
It seemed like he was trying to bring it back to this case somehow, kind of needle the judge a little bit. But
That's how it felt to me.
yeah.
So that judge was later, it turned out to be baseless, right? So it seems. So if I'm being investigated for something very serious that will cost me my reputation, my career, my bench, everything. And I know it's baseless, and you accuse me of it. How am I going to react? Not well. Let's say he did it. He's still not going to react well. You have no upside. What is your goal? That's what I take on.
About the judge's reaction to the claim, like, could his reaction be used in this other case? And like, what do you think about the raw emotion the judge showed him?
I would think that if you're under an investigation like that, you can look at the tapes for all different types of cases, and that the reaction doesn't bode well for you, but obviously it didn't have an effect.
So he made statements. He started to say what he didn't do.
Yes.
So he made substantive statements like, all I did in that case was A, B, and C. Okay, you just made a statement. You know, that old whatever you say can and will be used against you. He could have shut that whole thing down without ever making a statement that could have been twisted or turned or used against him. So, and I do think that generally it's very hard. I cannot imagine how hard it is to remain calm when you're falsely accused of jury tampering as a judge. But any lawyer advising him would have said, if that ever comes up, remain calm. I'm not being critical of him. I can't imagine it, but,
you know what?
It's the right move.
It's something I say. Less is more.
You do say less.
I say that a lot.
When I start talking.
When you start talking. No, but when you're negotiating or talking to the other side, you have to listen, and less is always more. So it's like as much as you want to go off or as much as you want to say stuff, it's like less is always more. All he did was potentially give that attorney and whoever was investigating him more to look at. Just don't say anything.
Next, we're in Denver, Colorado, for the deposition of attorney Robert Abrams. Abrams' firm was added as a defendant alongside their client in a lawsuit between two former business partners, and are being sued for fraud, conspiracy, and aiding and abetting a criminal by the plaintiff.
Good morning, Mr. Abrams. Do you understand why you've been asked to give your deposition today?
No. Literally, I've seen thousands of people give an oath in a deposition, but from the way he raised his hand to the way he started, this is not going to end well. Now, I know we're watching this, so I know it, but as someone who's done it, I could have already told you this is going to be a memorable one.
To say tensions are high in the room would be an understatement. Asking the questions off camera is the plaintiff's lawyer, Tom Werge. And on the other side of the table is Abrams' lawyer, Neil Sullenberger.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Objective form. Move on.
That's so funny. That's a litigation attorney acting almost like he's his own lawyer.
Got his role.
Yeah.
Well, his lawyer is supposed to say objective form. He's supposed to let his lawyer do that, but he's a lawyer, so he couldn't help himself.
Quick way to object during a deposition, and in effect, ask the attorney to clarify the question.
Have you been deposed
Objective
before?
form. Objective form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master. Good morning. Yes, we are in the middle of a deposition this morning.
But when the special master isn't available, plaintiff's attorney Tom Werge asks the same question again.
Mr. Abrams, have you had your deposition taken before?
And gets the same answer.
Objective form. Asked and answered. Move on.
You need to answer the question.
The question was answered. Excuse me. Have her read it back.
Yep. Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing you.
We're going to move for sanctions
I'm
against
asking
you.
to
if you're not
answer
going
your
to
questions.
allow
He just
her-
answered the question.
I just want to point out one thing. This is literally over him going, I don't remember if I took a deposition. What are they fighting about? They haven't even gotten anything. Nothing's even happened. And they're fighting about this. This is why you can't have lawyers in the same room.
His own objections, which a witness is not allowed to do during a deposition.
I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Objective form.
For continuing to obstruct and not answer any of my questions.
Objective
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3 sanctions.
We're going to move for harassment sanctions against you right now.
Things only get worse when the arguments take a personal turn.
We're going to be here for a long time today if you do not answer my questions. I can't even get through my initial questions here because you are being so obstructionist.
That's
today.
because you're a weak lawyer. You have us down for fraud. Ask us fraud questions.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to form.
None of your business. None of
Privilege.
What are those other pills?
Object to form, object to privilege.
None of your business. But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
This whole thing is childish. This is not normal. This is ridiculous. Everyone in the room needs to chill and understand what their goal is of this deposition. But once you go personal like that, you risk losing your credibility when the rest of this stuff comes up.
Also, it looks a little weird. Like, why are you taking any sort of pills like in the middle of a deposition? Maybe if it's Tylenol and you're like, I want to take a break or something like that. But to just start taking pills like in the middle of a deposition is a little bit awkward.
You could he's a lawyer. He knows full well he can take a break whenever he wants.
Yeah.
There's a lot of ways you can object to a question. You can say objection, it's leading. Objection, asked and answered. Objection, assumes facts not in evidence. Objection, hearsay. Objection, lacks best evidence. So there's so many reasons to object to evidence or to questions that are all very legalese, right? What's happened is some states have said depositions are taking too long. We're fighting over too many things. There's no judge in the room at a deposition. So just say object to form. And when we get to trial, we can argue over what was right or wrong about the question. So it's a way to simplify depositions. And it does do that, but it doesn't always work.
Called me fat when you walked in here.
Objective form. If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions today. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition.
Please do.
Here's the worst part. Until he went to the weight stuff, he had a really good argument from what we saw that he answered the one stupid, meaningless question to the best of his ability, move on. The plaintiff's lawyer wouldn't let that go. It had been answered. But now, don't you think he hurt his situation?
Yeah, he was just being attacking, but I think he felt attacked. So he was just like, I'm gonna let you have it. But it's silly sometimes the questions that certain attorneys do ask. I mean, we've been part of depositions where the guy's 30 years old and they go back to when he was 5. Like, why are you asking these questions?
I agree. And asking over and over and over, have you given a deposition? I think so. How many? I don't know. Have you given a deposition? I've answered it. Have you given a deposition? I can't give you more than I think so, I don't remember. So that was all on the plaintiff's lawyer, totally unnecessary. I definitely think he was doing it. If he's an experienced lawyer, he was doing it solely to get under his skin.
Yeah.
And then it worked, which is, as a witness, don't let the jerk lawyer win.
After reviewing the transcripts from the deposition, the special master issued an order for sanctions against Abram. His behavior during the deposition, along with other misconduct in the case, would ultimately earn Abrams a 9-month license suspension.
That's crazy.
9 months. There's got to be more. They did say there's more. 9-month suspensions are not given out lightly. That's a huge, huge deal.
Especially for it to be a 9-month suspension just for like what happened in the
we
deposition.
saw, come on.
That was not. Yeah.
But they said there's more. There's got to be more.
There's always more.
But it's just so frustrating. If you really felt they had nothing, then just trust. Trust the evidence. Trust me as your lawyer.
Answer the questions.
And maybe he did it, but if he didn't, his lawyer, the guy who was being deposed, the witness, should have stopped that, took him in the hall and said, you're either going to trust me and do what we've talked about and what you would advise someone to do, or we're going to just end this for the day because you are burying your own grave. Do you trust me or not? You hired me. Do you trust me? Because he would never let that guy had a strong personality. He would never let his own client act that way. But when you're in it, it's a lot harder, I'm sure.
Our next story takes us to Clark County District Court in Las Vegas.
I know this
for
one.
A kidnapping trial.
The defendant is here. He's in custody.
There's just one problem. The defendant's lawyer is nowhere to be found.
Can you check and see if he's going to join us?
After a 90-minute delay, defense lawyer Joseph Caramango finally arrives in the courtroom.
Have you seen this?
I think I have seen this, but it's been a long, long time.
I know this.
If a lawyer is 90 minutes late, do they actually just sit there and wait, or does it come to a point where they're like, okay, we're done for the day?
Every judge is different. Every county is different. So it totally depends. Some judges, if they have a busy calendar, would just put it off to the side. But this is a trial setting. Nothing else is going on. So I think most judges would leave the bench, let the other lawyer do some other work. But that may have happened. In fact, my guess is that did happen in spite of the way it's been edited here, so that everyone could do things but stay close, because they have a jury ready to go. They have a defendant ready to be tried. Everyone's ready to go. Where is the lawyer? Like, that's highly unusual.
I do feel like usually the judge or the judge's clerk will reach out to the attorney's office and try to find them.
Happening.
So like they're trying to find them and figure out what's happening.
And you can be late. I mean, you can't be late, but it does happen. If you're going to be late to court ever, let alone for a trial, most lawyers would feel compelled to call up, email, beg, explain. So to not just show up for 90 minutes, if that's what happened. This is a crazy start. This is about to get crazier.
Judge, I was heading east on Sahara Drive, and I was rear-ended, and my car was undrivable. The person who hit me took off, and
Hit and run.
it was a hit and run, and here I am.
I'm going to tell you, be honest with you, you don't look right this morning. That's why I'm concerned.
Judge, my neck and my back is killing me, but I'm ready to go forward.
You don't think you need medical attention?
I think I do. I think I do, Your Honor. I may have suffered a concussion, Your Honor.
Because you hit your head?
Because of the whiplash, Your Honor. I've had multiple concussions before.
You've had multiple concussions.
Yes, Your Honor. But I feel like I can go forward.
You know what? Can I just see everybody back in chambers?
Behind closed doors, Caramango meets with the judge and is assessed by a courthouse nurse.
And the record reflects that Mr. Caramango is back in the courtroom. He has been checked out by the nurse.
I've seen this, but you do see they got the bailiffs, the officers hanging out in the back. Court security is in the back. That's not a good sign.
Now, the nurse said you told her you got hit from behind and then you hit a car in front of you. Okay, you left that part out with us.
Yeah, I did, Your Honor.
So you also hit a car? So it was a double hit and run.
I guess.
The judge is becoming increasingly suspicious of Caramango's story, and the prosecuting attorney isn't doing him any favors.
My observations were observing him that there was clearly something wrong with him. I noticed he was slurring his speech. I noticed he seemed unsteady on his feet. And when actually Mr. Caramango came back into the courtroom, he seemed very unsteady on his feet as he walked by and actually ran into our counsel table.
Things only get worse for the defense lawyer when the judge orders him to take a blood alcohol test.
I think you have a concussion. I think you're dazed and confused and can't tell a straight story because you're too intoxicated.
I admit that I did have drinks last night, and I lost my grandmother about 2 weeks ago. I've been under a lot of pressure, Your Honor. I'm well aware of that.
So if you came to court intoxicated, you have a problem. Do you understand me?
Your Honor, I can represent as an officer of the court. I am not intoxicated.
Okay. So just go ahead and blow. Let's get it over with.
Go ahead, sir.
Can you imagine
Being the client?
How do you think about that? Oh my.
I'm just watching the client. You're like, no, I'm just thinking about being the attorney.
Like right now, his heart has to be beating 1,000,000 miles an hour. I don't even know what the law is if a judge tells you to blow, because like out on the street, it's a different world.
Yeah.
This is crazy right now.
Imagine they were there for a DUI and his attorney
Right.
got a DUI.
But he's on trial for kidnapping.
Oh.
Like this dude's facing years, and his lawyer shows up 90 minutes late drunk. Allegedly. We're about to find out.
That was close.
You want to show me? Okay.
I am stone sober.
Mr. Caramango, if I was you, I would just be quiet at this. Okay, for the record, your blood alcohol is a .075.
Even though his blood alcohol content is slightly below Nevada's .08 legal limit for driving, the judge has had enough.
I have no desire to ruin your reputation or anything. We'll deal.
This is what happens when people talk about legal issues. If you're .075 after you've been in court for probably an hour and a half here,
Right.
you showed up in court too drunk to drive. And it doesn't matter if you're too drunk to drive. Way before too drunk to drive is too drunk to show up in court and represent a kidnapping defendant.
I'll give you an opportunity to get it together, but at this point, I cannot absolutely allow an attorney to proceed.
The judge declares a mistrial, and Joseph Caramango's law license is put on disability inactive status. He's prohibited from practicing law in the state of Nevada and has not petitioned the state Supreme Court for reinstatement.
Well, that makes sense.
I mean,
He has a problem.
he's probably got a problem.
You know, being a lawyer is not easy. I always tell people, like, don't go to law school unless you really want to be a lawyer, because there's a lot of professions that have a lot of stress. So I think there's a lot of lawyers who have problems like that.
Alcoholism and drug
Yeah.
issues are very high amongst the bar, which people
Yes.
wouldn't think. But
Yeah,
it's a lot.
I never thought that. But then once we were lawyers for a bit, I was like, wow, there's a lot of lawyers who turn to alcohol.
If that guy that was being represented by the lawyer that was drunk, and that affects his case negatively, is he able to like sue the legal of the law firm? Like, I know it was a mistrial. I feel like if I had my lawyer showed up drunk and that affected my case, I'd be like, we got to do a redo. This is not fair for me.
So it depends on whether it's criminal or civil. That was a criminal case. It's called inadequate representation of counsel. Yes, if you can prove that your drunk lawyer fell below the standard of care for lawyers, you can get a new case. The fact that he was drunk helps you. However, there are people who have been sentenced to death and their counsel was asleep at the table for a lot of their trial, and we still let them be put to death. So it is sometimes not as simple as it may sound. Because I would rather a drunk lawyer than a sleeping lawyer. I don't want either, but if I had to pick.
What if he was already in jail, waiting for his trial in jail, and then he has a mistrial because of this negligence from his lawyer? He has to go back to jail for an extended period of time. Is there anything?
That's a great question. If he's found not guilty, he could sue his lawyer for something called false imprisonment, which is a civil action for money, saying I spent an extra 6 months in prison, or whatever it was, because you're drunk delay and you owe me money for that. And if he can prove it, he wins. All right. If you liked what my brilliant wife, Alexis Breyer, had to say, or maybe even didn't hate what I had to say, and you want to hear more, don't forget, like, subscribe, follow. Now, hold on for a minute. See that? YouTube's like, click that, yo. It's amazing. Do it. Let us know what you like. We'd love to hear it. Thank you for watching the Husband and Wife Law Team. Actual real lawyers who fight, commenting on what happens in court.